Friends, in this audio clip, I would be discussing to you with the procedure of hearing by the collector and passing of award in the land acquisition proceedings. Friends, once when the notification is being provided to with, then the next step goes is the hearing of objection by the person who is interested in. That is, under section 21, notice to the person interested shall be provided with. That is, the collector shall cause a notice on to the person who is interested in and also announce this in the official website and also at the convenient places, expressing the government intention of having taking the possession of the land. And class 2 of the same section says all those persons who are interested in the land to appear before him in personally or by an agent or an advocate not being less than 30 days or not more than 60 days after the date of publication. The interested person shall state the nature of their respective interest in the land that which they claims for a compensation and also seeks for the rehabilitation and resettlement along with their objections. Under class 3, we also say that the collector may, in any of the case, if he requires so, then make such statements referred to and this should be made in writing and signed by the party or his agent. In a way or otherwise than ways, we can also say this: the collector can call upon any objections to be made in writing signed by the person who is objecting upon with. Under class 4, the collector shall not serve any such notice to the effect of the occupier if that all such person interested in known to be believed that they are interested in. That is, where if the collector is satisfied knowing that the persons who claims to have an interest are not so interested in the land, then he may not cause a notice to all such person who are believed to be called as they are interested in. Whereas under class 5, we see that where a person so interested resides elsewhere other than the place where the land is acquired with, or if an agent is there, then the collector should ensure a notice is sent to him through post in letter addressing upon him to the last known residence where the person actually resides with, or to the address of the place where he is put in or where the business is being carried, and also undertake to publish the same in at least 2 daily newspapers where in the person happens to reside with, and also notify this the same in official website. After such notice is being served upon to the person interested in, then comes the enquiry into this. That is, section 23 provides that the collector shall cause an enquiry and to safeguard the interest of all those interested person who might have come before or also who might not have appeared before him. And in hearing the objections and in awarding the compensation, the collector shall also look at the estimate of the value of the land given to with, and a due consideration should also be given to the existing value of the land and other specific factors that can be used as a criteria in declaring the compensation. So on such enquiry so completed in the acquisition proceedings, then the collector is required to make an award within 12 months from the date of publication of that declaration. If no award is being passed during the period of the entire proceedings of acquisition is going to be get lapsed, provided where the appropriate government shall have a power to extend the period for further period of 12 months if it is of the opinion and in the circumstances existed are justified for the same to extend the term for the further period of 12 months. Here, the award is said to be not just what is being declared, it shall include the total compensation to be paid, which includes the solatium amount that shall be payable to that of the land losers, and the solatium amount shall be equivalent to the 100% of the compensation amount along with 12% of interest calculated on the amount of compensation from the date of publication of the notification of, that is, SIA study. Whereas in case of the old act, if you see, the solation amount was only 30%, but new act confers to say it is 100%, of which the amount shall be paid to the total amount of compensation that is going to be awarded with. And under section 24, if the land acquisition proceedings are initiated under the old act and no award has been made, then all those provisions of the new act is applicable to such person in granting of those award. Where the award has been made under the old act, then such proceedings shall continue under the same act, that is the old act. Where if the award is being made prior to the period of 5 years of the enforcement of this act or more to the commencement of the current act, but the physical possession of the land is not being taken or compensation has not been paid, then such proceeding shall deemed to be have been lapsed, then the appropriate government shall initiate a proceedings in such land acquisition at fresh in accordance with the provisions of the present act. But we also see where an award is being made, and if the claimant has not accepted the award, or if the acceptance is with the protest by the claimant, then the award does not represent to the market value of the acquired land, then it is, or if the amount so obtained is under the protest, then such claimant has a right to make an application to the collector to refer the matter to the civil court for determining the market value of the land so acquired by them. Now we spoke about with the market value. Now what is a market value and what is the yardstick that the collector has to take in determining as to the market value should also be understood by us. In fact, section 26 of the act, which speaks for the determination of the market value of the land by the collector. That is, the collector 1, we shall say, the collector shall adopt the following criterias in determining the market value of the land, which every one of us is required to know upon with. That is, what is the market value of any specified land in terms of Indian Stamp Act 1899, or where the land is situated. In a simple manner, I can say that if the land falls within the area as specified under the Stamp Act of 1899, then what is the stamp duty, or what is the Stamp Act which speaks with the market value of the land would be undertaken with, or would be considered with. The second one is the average sale price for similar type of land situated at the near vicinity of the land is also considered with. The third one is the consulted amount of compensation agreed under section 2 class 2 in case of acquisition of land for a private companies or PPP projects, whichever is higher than the consent agreed amount would be considered to be as a market value, and it shall be the date on which notification is being issued with. So these are one criterias wherein the market value is taken. The second one is the market value is also calculated and it shall be multiplied by the factors specified in the provisions specified under first schedule of this act. The third one is the market value under subsection 1 cannot be determined for a particular reasons. That is, if a land is situated in that area where the transaction of the land is restricted under any other law for the time being in force, then that area of land cannot be ascertained for its market value. Whereas, apart of all those things, there shall also be an award of solatium amount under section 30. That is, the collector having determined the total compensation to be paid shall arrive to a final award imposing a solatium amount which is equivalent to the 100% of the compensation as specified under the new act, which I have also discussed previously. In this, the collector shall issue an individual award detailing the particulars of compensation which shall be payable to the person as specified in the Schedule 1. And also, in addition to that of the market value of the land that is being provided under section 26, the collector shall also award an amount calculated at the rate of 12% per annum of such market value for the period commencing from the date of publication of notification and SIA in respect of the land till the date of award where the collector is being made, or till the date of taking the possession of the land, whichever is earlier. So under these factors, my friends, we see the award are going to be made, and once when of all these things is being made, under the new act, we see once when all this is been completed, there is a proceedings is said to have been complied with respect to the acquisition. But under section 93, which provides saying that if the completion of this acquisition is not necessary to be have done, and the appropriate government can take a further step in denotifying of such acquisition. That is, the appropriate government is at the liberty to withdraw from the acquisition of any land which is in possession has not been taken up by the collector. That is, the collector shall determine the amount of compensation due and the damages suffered by the owner and as a consequences of notice and proceedings thereon, and if that is to be awarded. So if this is not been made, if no acquisition proceedings is being made, no award is being given, then the central government or state government has a power to withdraw such acquisition wherever it finds necessary. In such cases, the collector should also determine the amount of damages what is being incurred by the person in respect of those acquisition in which the government or the authorities have taken with in that. And also the government can withdraw from the proceedings of acquisition before the possession is taken or before the award is being made by issuing a notification in relating to the land of acquisition. In fact, the current act does not speak anything about denotification, and the old act spoke upon with this, but only thing what the new act says is that is the central government or state government has a power to make a notice or cause a notice of making no acquisition where there is no completion of acquisition is made with. And after the award is being so made, that is, if after the award is so made but not been granted with, then no such acquisition proceedings cannot be withdrawn with. Or I can also say you in this way, after the award is being passed, the withdrawal of acquisition proceedings is prohibited on the part of the government, whatever may be the circumstances, except wherein the proceedings are declared to be invalid by the court decree in the civil court. Otherwise than this, in all such cases, we see the acquisition proceedings becomes complete. So my friends, what we understand here is this: once the preliminary notification is being made, the person interested in can bring an objection, and in respect to the injunction, the hearing would be heard by the collector, and after having heard by the collector would go in fixing the compensation, that is by an appropriate authority with relying upon all the parameters to it. And even in awarding this compensation, they take the market value and also what shall be the loss that is being caused by way of acquisition, wherein if anything is being attached to that of the land which is being acquired and the interest that is being payable on that, taking all this into a consideration, the award shall be made by the authority to that of the person who is being affected by this acquisition. As I then said, when market value is not considered worth, that is, where if the land is situated in such area where the transaction of the land are restricted by or any other law for the time being in force, then the market value of these above factors cannot be taken to worth. Or if the registered sale deed or an agreement to sell for similar kind of land is not available immediately for the preceding 3 years, then the market value is not considered in. Or we also say that where the market value is not specified under the Stamp Act, then the state government is concerned shall specify the four floor price of the minimum or the minimum price per unit of the said land based on that of the criteria what they have adopted in the calculation of the award that is to be made. That is, the price should be calculated in accordance with that of the government. In such case, the requiring body in any of a case, they can compel upon any owner of the land to take their shares and the value in which they are being deductible and the value of the land which has been calculated as that is by the appropriate government. So also the collector shall, before with an intention of making any land acquisition proceeding in the area, shall take all such necessary steps to review and update the market value of any land on the basis of the parameters that is being fixed in that area. So in determining the amount of compensation, the collector shall determine the market value of the land so calculated, and the total amount of compensation is required to be paid to the landowner, including those things which are attached to the land. Now, what are the parameters that are considered in awarding a compensation? Friends, as I then said, the first one is the market value will be determined under section 26 and the award of amount is in accordance with or passed in accordance with schedule 1 and schedule 2. If no market value, then the appropriate government has an authority to say what shall be the amount which shall be paid to that of the land losers in the course of its acquisition. The second thing is that the award shall also look into these aspects, that is, damages sustained by a person who is interested in by the reason of taking of such land wherein there is a standing crops and trees in which a land is being taken away from its possession. This is one another parameter which has to be looked in. The third one is the damages, if any, I repeat, if any, sustained to the person interested at the time of the collector taking the possession of the land by the reason of acquisition, resulting in injury or which is injuriously affecting to the other's property, movable or immovable, if any, or in any other manner of their earnings, then they should also be considered in. Fourthly, again the damages, if any, sustained by a person interested at the time of the collector taking the possession of the land by reason of severing of any land attachments to the land or in any other's land. And the fifth parameter is by the reason of this acquisition, if he is compelled to change his residence from one place to the another place or change the place of business, and then the expenses incurred to a person in respect of the same shall also be duly considered in for the acquisition proceedings. And to that of my next slide, it is also that, my friends, if the damages claimed so, if any, is bona fidely resulting in by in diminution of profit of the land between the time of the publication and the declaration under section 19 at the time of the collector who is taking the acquisition or who is taking the possession of the land should be given a due regard. And seventh one is it could be on any other grounds which may be found in the interest of justice, equity, and to the benefit of the beneficiaries who are of the affected families, the consent shall be given to in calculating the awarding of compensation. So all these are the procedures, my friends, which we would always look in awarding the compensation to the person who is interested or who has lost their land in respect of the acquisition proceedings. How determination is taken with the things attached to the land, that is under section 29. There are three factors which are being taken with. One, where if the assets are attached to the land or building, then they can use the services of a competent engineer or any other specialist in this area whom they may consider it necessary for the purpose of ascertaining the value of it. The second one is when the trees or plants is involved in the land so acquired by the authority, then they can use the services or and any experienced person in the field of agriculture, forest, horticulture, sericulture, etc., where they again consider it necessary. And the third factor is that where if it is a standing crops, then the experiences of the person in that field can also be considered in determining the value of those properties which is going to be severed, that which is attached to that of the land. In our previous slide, we have discussed with the procedure for the acquisition and also the procedure that is required to be followed in awarding the compensation. Friends, today with this part, I would be discussing to you with how the rehabilitation and resettlement should be carried with. We would be understanding what is rehabilitation and resettlement. So also what are the provisions that is being provided for rehabilitation and resettlement, and also how an award is going to be made and the corrections also that could be made to this award. What is the procedure in respect of passing an order of rehabilitation and resettlement, and also my friends we shall be looking when there is a completion of acquisition of proceedings. In fact, my friends, the entire process of rehabilitation and resettlement takes place between the adoption of section 11, that is preliminary notification, and declaration of the award, that is section 19. That is where under section 16 of the act, after issuing a preliminary notification by the government, the administrator for rehabilitation and resettlement shall be appointed, and he shall conduct a survey and make a census of the affected families. Based on the survey of the census report of the administrative officer, they shall draft a rehabilitation and resettlement that which should be provided for those of landless persons. And this landless person here, it means to say the persons who have lost their livelihood, or it is the person who have lost the life of them, where they are primarily dependent on the land which is being acquired with. So considering these persons, the draft of rehabilitation and resettlement scheme shall be made in a prescribed manner and within a prescribed time for the implementation of rehabilitation and resettlement scheme, and it shall be also been made known locally. And also friends, in the preparation of the report, the administrator shall give a public hearing by giving an opportunity to raise an objection against the acquisition of any proceedings that is being made by the government or against the rehabilitation and resettlement scheme. After this, there shall be a preparation of the report. The administrator shall give a public hearing and also hear allow the person to raise their objection in respect of any accusation, and whereafter the report has to be made. Once after having concluding the public hearing, the administrator or officer shall submit a draft scheme of rehabilitation and resettlement along with the report of the client's objection which is raised in the public hearing. After reviewing this by the collector in turn submits his report along with the suggestions to the commissioner of rehabilitation for rehabilitation and resettlement for his approval. The appropriate government or the collector, after having been satisfied with the report and also with all the particulars that is being needed for the public purpose, the declaration shall be made to this effect, and this declaration shall be accompanied with the summary of the rehabilitation and resettlement scheme, and also unless the compensation has been deposited either in full or in part, no declaration shall be carried or no declaration shall be effected.